argument against the remand, but we would like to address bond, given that my client is now only charged with a misdemeanor.
I'll continue the defendant's not guilty plea to count 4.
Welcome to a courtroom where addiction, bad choices, and bold excuses collisions. Today, we witness Judge Simpson handling a docket full of defendants who are pushing the boundaries of the law and logic. We've got a woman claiming a 48-year habit makes her drug tests impossible to pass, a Zoom appearance that turns into an accidental adult film, and a man who literally blames a stolen phone for his missing bond reporting. Will these excuses hold up? Or is Judge Simpson about to send everyone to lockup? Let's dive into the chaos.
Good afternoon, Your Honor. Jonathan Sachs for Mr. Safety. Boss Safety, Your Honor.
All right, thank you. All right, what are we doing?
We are here for a negotiated guilty plea.
All right, I have a plea form before me indicates that the defendant will be guilty to the charge of larceny by false pretenses under 200, 93-day offense. Upon his successful plea to that charge, count 1 would be dismissed. There is also the agreement that the prosecutor will recommend or is okay with the highest sentence, and restitution is agreed at $500.
That's correct, Your Honor.
Okay, the sentencing judge waiver box is not checked, but I view that as an oversight, so I'm going to check that box.
That is purely my oversight, Your Honor.
I have him sworn.
Raise your right hand. You solemnly swear to the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Boss Safety.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the offense of larceny by false pretenses under $200.
Yes, Your Honor.
That is a...
Wait, did she really just drop the 48-year habit defense? Edna is trying to argue that nearly 5 decades of usage has turned her system into a permanent reservoir for cocaine. She's basically telling the court that once you're a long-term user, the science of drug testing just breaks. But here's the legal breakdown. The court doesn't need to see levels dropping if the test is positive after a misscreening. In judicial terms, a mistest is a guilty test. Judge Simpson is clearly skeptical, and for good reason. She's shifting the blame to the testing facility's methods rather than her own choices. Is this a medical anomaly or just a masterclass in gaslighting the bench? Let us know in the comments. Do you buy her excuse?
Misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the false pretenses. If that's greater than $500, that becomes the maximum fine. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this matter, and you would be sentenced before Judge Perry in the 15th District Court.
Yes,
You
Your Honor.
understand that?
Yes, Your Honor.
Understanding all that, still wish to plead guilty?
Yes, Your Honor.
All right, and to that charge, how do you plead? How do you plead?
What do you?
Guilty or not guilty?
Oh, I plead guilty.
Yeah, right. You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct, sir?
Yes, Your Honor.
Any questions regarding those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in that.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes.
March 16, 2025, at the location of 516 East Liberty Street, City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do what'd you do that makes you think that you're guilty? Let's do that.
I used the card that was not mine to pay for the parking structure.
To do what?
To pay for the parking structure.
Okay. So the card was not yours?
Yes.
You didn't have the owner or device holder's permission to use it?
No, I just did.
And you did not inform wherever you were using it that you didn't have permission?
No.
Right? And because of your use, you obtained goods or services?
No.
You didn't get anything?
No.
What happened?
Your Honor, it was rejected, but he still used the financial transaction.
Got it. Okay, but he didn't get anything from it?
No.
Okay, then I'd have to certainly take it as to the higher charge, which is actually the use, because there was no value done. Okay. Sir, if I accept your plea, I do have to advise you that between the time of my acceptance of your plea and your time of your sentencing, that if you commit misconduct as defined by the Michigan court rules, that number one, the court would not be bound by any evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea to count two, particularly under the higher offense version. Count one is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be January 30th, 2026, 8:30 before Judge Perry.
Your Honor, is there any chance of another date? I'm looking forward to being right here on January 30th at 9 a.m.
Oh, I'm sure there's, another day. I don't have it. So what you can do is I have to give you this date. You can contact 15th. They'll be more than happy, I'm sure, to accommodate another date.
All right, thank you.
Thank you. Court does call the case. People versus Trevor Howard.
Assistant Public Defender Ben Dunaway on behalf of Mr. Howard, who is standing to my right.
Time and place scheduled for prelim, and unfortunately, people are unable to proceed in anticipation of a motion to dismiss the felony counts and seek a remand on, I believe it's count 4, Your Honor.
Yes, it would be count 4.
And we would make that motion. We don't have a
This is a
legal.
moment that redefined Zoom court forever. Jessica Bracella didn't just break courtroom decorum. She completely demolished it. Imagine the judge having to pause proceedings to review video evidence of you appearing to have, well, bedroom business while on the clock with the court. This is exactly why Judge Simpson is now mandating in-person appearances. When you treat a serious legal proceeding like a private chat, the privilege of remote access gets revoked immediately. This isn't just about disrespect. It's about the total collapse of the judicial atmosphere. The judge's wow says it all. Would you have the guts to even think about doing this? Or is this the ultimate level of not giving a care?
Argument against the remand, but we would like to address bond, given that my client is now only charged with a misdemeanor.
I'll continue to defendant's not guilty plea to count 4. Counts 1, 2, and 3 are dismissed. A pretrial date in this matter will be set
January 15th at 10:30.
January 15th, 2026. What time is it? 10:30, of course, before Judge Freshour.
Thank you, Your Honor.
Is that A3 or A4?
Pardon?
10:30.
10:30.
Oh, I mean the court.
That's actually A4.
Okay. And may we address bond, Your Honor?
Go ahead.
So, Your Honor, my client works Monday through Thursday at Cushing Malloy Books. He works 410, so that's 40 hours a week. Then he additionally works at Hollywood Sales doing car audio Friday, Saturday, and some Sundays. So he is fully employed. He lives with his mother in Ypsilanti. He is her caretaker. She has cancer. That's on Clark Road over in Ypsi. And he does have a pretty limited criminal history, I would say. So we'd ask the court to release him to his mother's house, and the court can impose conditions as the court feels necessary, of course.
What happened? Well, there's a problem. Because the defendant initially had a personal recognizance bond, but then he violated. Yes, twice. But he definitely violated where the court felt it necessary to issue a no bond warrant on him. So what makes me think, even with charges where they are, that the defendant is going to be able to comply with bond conditions?
Well, I would say, if the court thought he strangled the person, he's a lot more of a danger to the community than if he had committed misdemeanor domestic violence. Just because of the
And the excuses keep rolling in. Now we have Christian Schukaikart, whose defense for missing mandatory reporting is a classic. My phone was stolen. It's the modern version of the dog ate my homework. Judge Simpson is highlighting a massive hole in this story. The public defender's office has 80 employees. Yet neither he nor his wife could manage to leave a single verifiable message. In the world of bond, communication is your only lifeline. When you stop responding, you become a flight risk in the eyes of the court. The judge is cutting through the overwhelmed narrative like a hot knife through butter. Do you think a stolen phone is a valid reason to ignore court orders?
The nature of the charge, I think. If you're a person that would do that, you could be considered more dangerous than a person that commits misdemeanors. He's no longer charged with a felony. The witness apparently was not interested in pursuing the case. So I don't know what happened. I think as far as him violating bond, he's certainly learned his lesson. I don't think he's a frequent flyer here that has violated bond in the past or anything like that. So if the court would give him another chance, we think he would comply this time.
I don't really need anything from the people, but I'm just going to tell you, the defendant hasn't been able to comply with bond. It now becomes Judge Freshour's issue to deal with, and I'm going to certainly leave it to her to decide the conditions of releasing the defendant. Your motion for bond reduction tonight, bond will continue.
Thank you, Your Honor. And sir, would you state your name for the record, please? Tyler Witherspoon. Your Honor, we've worked out a deal involving a waiver and a plea at circuit court in this matter.
Correct, Your Honor. My understanding is that Mr. Witherspoon will waive his right to a preliminary examination. The people will not file a vigil in this matter. And in circuit court, there'd be an offer for a plea to an added count of possession of less than 25 grams of controlled substance.
Have his bond violation?
I do. So, well, can I address it on the record, Your Honor?
Yeah, go ahead.
I talked to my client about it. His position is that he was incarcerated. You know, I think he admitted the first violation, to Your Honor. He denies this one, and he's paid, I believe it was $150 for the sample to be retested at a lab. So, given that the retesting is in progress, I'd ask the court to defer any action to Judge Conlon, and perhaps we'd have those test results back in 2 weeks, or I mean, if they came back later than that, I'm sure the government would be addressing it regardless.
Does he have a medical marijuana card?
No, I mean, I don't, that was why I had the, last time I asked you, I told you about the appointment, and that was the whole thing. So we trying to get a medical marijuana card right now. I got a doctor appointment scheduled on February 11th for all of this. In the cocaine drop, I don't see how it was positive, and I'm supposed to test today too, actually. So I'm trying to figure out how. I don't understand how is it dirty. That's why I paid for it to get tested again. They told me it'd take up to 2 weeks for it to come back from California. And regards to,
well, maybe if that's the case, I mean, except that, and here's the problem, counsel, I might wait, except that his last 3 tests have been positive for cocaine spanning from November 17th to December 26th. And then he had the THC positive in November, but then THC leaves his system, and then he's
it's
back with THC in his system again.
I speak, Your Honor.
All right, if your attorney wants you to, I mean,
Don't talk about anything before November, but
This is the highest stakes game of let's make a deal we've seen all day. Mr. Witherspoon is putting his freedom on the line, swearing he's 100 clean despite a history of positive tests. Look at the judge's playful but deadly serious tone here. He's offering a gamble, go test right now. If it's clean, you're good. If it's dirty, ever is a long time. This is a classic test of a defendant's confidence. If you know the lab results are coming back dirty, this is the moment you fold. But Witherspoon is doubling down. Is he actually clean? Or is he hoping for a miracle from that California retest? The tension in the room is palpable.
I think we're fine talking to the court about his substance abuse issues. He's pretty open with it. You know, he admits he has an issue. I'd just say to the court, I think THC opinions have evolved, and you know, I haven't known Mr. Witherspoon very long, but he's pretty obviously in pain to me. Frankly, I think THC is better for a person than taking opiate pain relievers. He can barely walk. I mean, I think he needs,
That's good, doctor. I don't know.
he had a
I'm
doctor
trying to
appointment.
debate that issue. That's not it. And it may very well be, but that's why he needs to just get a card and then there isn't an issue.
I scheduled to make an appointment for the card. And the cocaine dirty, that's why the first time I told you, I said, Judge Simpson, I did that. This time I'm 100% sure I didn't do any drugs. So that's why I had it sent out for the test, because I know I can't be dirty for it. Would you allow me to take a test today to, like, I know I'm not dirty. I ain't using no drugs, man.
My name's not man.
Yes, sir. I'm sorry, sir, but I'm sorry, sir.
Just call him Judge is good.
And if it comes back dirty, I just leave you in there forever.
Ever is a long time.
I
sir.
know, but we're gonna make a deal. Let's make a deal.
Let's make a deal.
Is that it?
Deal.
If you come back clean, then I get to decide what to do. Let him know he's coming over to test.
Where's he going? To community
Community
corrections?
Any corrections?
All right. Obviously, if you come back, work out. So, come back.
Calls the case of the people versus Martinez Smith.
Good afternoon, Your Honor, Raymond Cook for the people. Good afternoon, man. Please sound the court. Kareem Johnson, appearing on behalf of Ms. Smith, who is approaching, standing to my immediate right.
Your name?
Martina Smith.
I have before me a plea form. Plea form indicates that the defendant is going to be pleading to count 3, attempted resisting and obstructing an officer. That's a guilty plea to 1-year offense. On her successful plea, counts 1 and 2 would be dismissed. And there's a sentence agreement of sentencing under HIDA. That's the court's full understanding.
That's correct, Your Honor.
Let's have her sworn.
Raise your right hand. Solemnly sworn to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
State your name, please.
Martina Smith.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer.
Yeah.
That is a misdemeanor, punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that? You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge, pardon? Falvo or her successor in the 15th District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question about any of those rights? Please look at paragraph 5. You'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you're guilty of this offense?
Yes.
On the date of July 28th, 2025, at the location of 3205 Boardwalk, City of Ann Arbor, Washtenaw County, State of Michigan, did you come into contact with officers from the Ann Arbor Police Department?
Yes.
And you'd admit they were in the lawful performance of their duties?
Yes.
How do you think you?
Finally, we see Martina Smith, and her admission is surprisingly honest. She didn't put her arms behind her back during an arrest. It sounds simple, but in the eyes of the law, that is resisting and obstructing. Even passive resistance, like stiffening your arms, can lead to a 1-year misdemeanor charge. Notice how Judge Simpson is walking her through the misconduct warning. He's making it very clear that between now and sentencing, she is on the thinnest of ice. Any slip-up and that sentencing agreement is out the window. It's a somber reminder that even a few seconds of defiance can lead to months of legal headaches.
Resisted and or obstructed them?
I didn't firmly put my arm behind my back.
Pardon?
I didn't firmly put my arm behind my back. Strangled.
Okay, so they were trying to arrest you
Yes.
and they told you to put your arms behind your back
Yes.
and you resisted doing that.
Yes.
All right. Young lady, if I accept your plea, between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor.
All right, court will accept the defendant's plea. Guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
January 20th at 9 a.m. before Judge Bello.
January 20th, 2026, 9 a.m. before Judge Ralvo or her successor. Will continue. Thank you.
Thank you.
Thank you, Your Honor.
Thank you, sir. Is that it for Mr. Johnson?
It is.
It is. Mr. Johnson, have a great new year, sir.
Thank you too, Your Honor.
Good afternoon, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Riddle, who approaches the podium. Please state your name.
William Michael Riddle.
Thank you.
Your Honor, this court is aware this time and date scheduled for preliminary examination. The people are unable to proceed this afternoon.
Your Honor,
Go ahead.
in light of the people's position, we would move for dismissal without prejudice.
People being unable to proceed, this case is dismissed on defendant's motion. That's without prejudice. Right?
Thank you, Your Honor.
Thank you.
And Your Honor, Happy New Year to you and your staff. And I failed to say it the last time. I hope everybody had a very Merry Christmas.
Absolutely.
We were a little more pressed last time for time.
Is approaching the podium now. And would you state your name for the record again, sir?
Terrence Witherspoon.
Today's your lucky day. You're negative.
I told you, sir.
Huh?
I told you. I ain't you.
No, you didn't tell me.
You gave me a pass. Listen, though, you gave me a pass, sir. You,
Huh?
you reinstated my bond. I was in jail. I cannot be. I'm not gonna test dirty. I can't.
Well, we can indicate he's got a future in acting, so he is employable, Your Honor.
Okay, so he's waving up. Is that right?
He is, Your Honor.
All right, so sir, waiving your right to a preliminary examination.
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
And you understand that you'll not have that here. You'll proceed to circuit court for further resolution.
Yes.
People also waive the right.
We do, Your Honor.
Preliminary examination hasn't been waived. Defendant's bound over on the single count.
And he did waive for the offer placed on the record 2 hours ago or whatever it was.
Yes.
Thank you, Your Honor.
Offer of use or possession, felony possession of controlled substance less than.
Yes.
And we will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
February 23rd at 1:30 before Judge.
February 23rd, 2026, 1:30 before Judge Hammoud. Bond will continue. Right? Mr. Witherspoon, you may not think so, but I am so glad that it came out that way.
Me too.
I really, yeah, you're probably more so than I am, but I really am, because I'm just, all right, good luck to you, young man.
Thank you, Your Honor.
All right, so, yeah, wow.
What a wild ride through Judge Simpson's docket. We saw the metabolic defense fail, a Zoom scandal that left the staff speechless, and a literal gamble for freedom. In the end, the courtroom is a place of rules, not just suggestions. Whether it's a 48-year habit or a stolen phone, the law requires accountability that these defendants are struggling to provide. The biggest takeaway? Respect the court, follow the bond orders, and for heaven's sake, keep your clothes on during Zoom. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments on which excuse was the wildest, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll see you at the next sentencing.